Good morning, everyone. Good morning. Happy hump day. A little bit late today, but good morning, everyone. If you're just tuning in for the first time, definitely say hi in the comment box. Let's know where you're tuning in from. Like us on Facebook, like us on Instagram, like us on YouTube, and subscribe to our channel. Hit the notification box so you're notified whenever we go live. Good morning, Sarah, on Facebook, and good morning, Starboy, on YouTube. Good morning, everyone. Let me introduce myself. My name is Aisha Chidowe. I'm an immigration attorney. I'm based out in Orlando, Florida, but I represent clients all over the United States and internationally with their family immigration matters. So your location does not matter. Wherever you're located, we're happy to help you. Good morning, Sophia. Thanks for tuning in. Good morning, everyone. Where y'all tuning in from? So today I want to talk about the dreaded denial letter and what to do. If you're denied, good morning, Macedonas. This is going to be a short live. I have an interview very quickly, so I need to be quick about this one. When you file for a marriage-based case, nobody goes in, with the intention or thinking, oh, my petition is going to be denied. But the facts of the matter is that, sometimes that happens. Your petition is denied. So the question today is, what do I do if my petition is denied? So there are three key options I'm going to talk about today. First one being, if your petition is denied, the first thing that needs to be assessed is whether or not it was an error that caused it to be denied. And if there was an error, I would recommend filing an appeal. What do I mean by error? So like things that I would consider errors are like, if they denied you because they asked you to send your I-864 back, or there was not a good financial sponsor, or anything like that, I would suggest, you basically filing an appeal to fix that error and to include that thing. Or if there was truly an error in the officer's judgment, you can then, ask for them to reopen your case and reconsider. So that's the first thing. Other times, and how, other times, I have clients that are not really sure. They thought everything went well. There was no potential issue, and there was a denial. We've had a case where the person was denied, and this was pre-COVID. It's not as easy to just walk in now for InfoPass. So we ended up ordering a FOIA. We saw there was really no reason for them to be denied. And I went in there with my clients, and, they admitted to their error in judgment and reopened the case and approved it that week, but that is when there was really nothing to have caused that denial. Now, if you received a notice of intent to deny, those are usually a bit trickier because, there are obviously a lot of discrepancies, which is what led them to giving you that notice of intent to deny. A lot of times the discrepancies could be in your testimony during your interview, or if they did a home visit, and there are a lot of discrepancies or what you submitted. In those cases, we have to evaluate whether or not you can move on to an appeal. What I look at for appeal is, what is the relationship with you and your spouse, right? Are you guys still, in a good relationship? Is your marriage likely to continue? And then depending on the answer for that, you can either do an appeal or you can file again. If you and your spouse still have a good marriage, you certainly can file again and use this opportunity this time to make sure you get it right and include everything that you need to include to show them that, look, you denied us, but here we are still here again because now we've gathered more evidence. Because sometimes they might deny you and say, insufficient evidence or not enough evidence to prove that you have a legitimate marriage. So you will have to provide newer evidence. Or sometimes they will specifically say that your marriage was a sham. If they say your marriage is a sham and you and your spouse are still together, I definitely recommend fighting that, because there is no way to overcome that. So you need to fight that and fight it to the nail to show that your marriage was not a scam, was not a sham, by providing additional evidence showing that, or if your spouse was intentionally trying to sabotage it to have that result, then the other thing you're going to be considering is a valid petition. So basically, in order of evaluation, we look at an appeal, reapplying, or a valid self-petition. For those of you who don't know what a valid self-petition is, a valid self-petition is basically the Violence Against Women's Act. This applies to both men and women. It's essentially saying that, my spouse tried to sabotage this interview. My spouse is abusive. My spouse didn't want me to get a green card because of that would mean that they can't control me anymore. And then you will, at that time, when you're submitting the vow, not only have to prove that your marriage is legitimate, you also have to prove that the reason why your marriage interview went that way was because of your abusive spouse and why they did that. So those are the three things, three options that I would say that you have. Obviously, with the denial, that your work permit technically becomes obsolete after 18 days from that denial. So, you submitting a new petition means that you'll be able to get a new work permit, whether it's an adjustment of status petition or a vow with adjustment of status petition. An appeal will not give you a new work permit. You're going to have to wait until they make a decision. Timelines could vary. Sometimes an appeal can take 6 months. Sometimes an appeal can take a year. So it just really depends. So those are basically the three different areas that I try to explore with my clients and the relationship that they currently have with their spouse to determine what strategy to take next. Like I told you guys, this is going to be a super quick one because I have a USCIS interview. I'm going to just answer 1 or 2 questions. Somebody says, if you're living with a woman in the States and you have your 2-year green card and the lady divorces you, can you get a 10-year green card? The answer is yes. So divorce is not a ban to you getting a 10-year green card. So if you have a 2-year conditional green card and you and your spouse get divorced, you can still apply for removal of condition, even if the divorce happened like a long time ago and you didn't submit your removal of condition application. The only thing is that you still have to show that you had a valid marriage, that your marriage was in fact valid and it wasn't done for the purposes of immigration. As long as you can show that and, basically have a statement or declaration of why your marriage didn't work, you still will be fine to get your 10-year green card. Good morning, Fafo, B from Orlando. Okay. I don't think I have any other questions. I am going to jump off. Let me just make sure that I don't have any other questions. Okay, guys, I don't have any more questions. I see some of you just tuning in right now. You can just, I'm going to save the video on Instagram. And so you can just, watch it from the beginning to catch whatever you miss. I'll see you guys tomorrow. It's just a crazy week for me dealing with USCIS interviews. So my lives are just going to kind of be sporadic. So just put the notification button so that you get notified when I come on live. All right, guys, have a good day.